Vermont versus Peter J. Boissoneault, docket numbers 2019-022 and 2019-023. Representing the appellants, Peter Williams and Peter Boissoneault, is Rebecca Turner. Seated at council table with Attorney Turner is Joshua O'Hara. Representing the appellee, State of Vermont, is Heather Gray.
Thanks. Counsel? There.
Good afternoon, Your Honor.
Good afternoon.
This is a consolidated appeal where Mr. Boissoneault and Mr. Williams challenged the voluntariness of their consent to submit to a search of their breath at the police station without a warrant. Because the relinquishment of their Article 11 rights was involuntary, the Vermont exclusionary rule requires that the evidence must be suppressed. Before the trial court, the judge examined and considered the argument as to whether the consent was voluntary by reducing the analysis to one of objective review of the officer's conduct, whether or not there was impermissible coercive conduct. This is not a complete analysis of the consent question before it. Instead, this court's precedent, following U.S. Supreme Court precedent, is that the totality of the circumstances are considered. That not just the objective conduct, the reasonableness of the police officers, but significantly the subjective intent or what was going through the defendant's experience and their minds at the time that they submitted to the warrantless consent. And that was not appropriately considered by the judge below.
So I'm understanding your appeal, and maybe this is wrong, as being sort of a categorical argument that the administration of the implied consent statute and the sort of script that's commonly used is inherently coercive, and therefore consent given to the evidentiary test following that, it can't be deemed voluntary. Am I understanding your argument, or are you finding unique facts in these specific cases that call for that conclusion?
I think to the extent that the form language used here pulled from the implied consent statute, which many forms do, there is, yes, this analysis would apply generally where the police rely upon the consent or the waiver of their right to a warrant to get to the breath. So in that sense, in terms of the analysis itself, it certainly isn't categorical, but we look at the individualized circumstances. Again, we look at, starting point, the words spoken to the defendants at the police station after arrest. The form language is both providing too little and too much information, the result of which leads to an involuntary consent that the court
So would that be
can't
across
rely
the
on.
board for any case involving an evidentiary breath test? We're talking about breath tests only, where a police officer would need to get a search warrant, even without, with somebody else agreeing to it, consenting?
I think that where this police is, they're relying on the implied consent statute in the form language, yes, I think that they are treading in risky areas where they're relying on the consent obtained to avoid the warrant requirement. And here's why.
Can I ask you a question
Yes.
before you move on? Okay, so you have somebody in custody. The officer says, all right, good, you're handcuffed to the wall here. We're going to get a warrant. They go and get a warrant and come back, and the defendant says, I'm glad you got a warrant. I'm still not taking the test. What does the warrant accomplish in those circumstances?
The warrant accomplishes the fact that an independent judicial officer has reviewed the circumstances and has determined that a warrant is needed. In that situation, the insistence to still refuse to cooperate turns into an entirely different set of circumstances, right? There we have a warrant validly issued. Now there are issues of refusing to submit, contempt, right? Possibly obstruction of justice. Certainly, though, the considerations at this stage of these cases, which is just that the actual refusal to submit to a warrantless search results in a crime itself, is where the significance of the differences here. Let's take a look at what the form language was heard, why it is both too little and too
I
late.
just want to go back to something you just said, though. You said that a warrant would show that there has been some finding that probable cause existed, maybe you didn't use those exact words, in order to request a test. But isn't that the very reason why the vast majority of courts, including the U.S. Supreme Court, have said that that's why a warrant isn't required? Because a police officer can't make the request unless that police officer has already found probable cause to make the request. So why the second review?
Yes. So under the Fourth Amendment, that certainly has been the analysis, and this court reviewed that and decided that in right. The request itself, if supported by probable cause. Article 11 is different, where the warrant requirement itself stands separate from the fact that the police officers can point to a probable cause requirement. But let's talk about, because the issue before this court with these cases is narrower. The question is whether or not the consent was voluntary, looking at the entirety of the circumstances. This is why I want to draw the court's attention to the specific language that they heard, right? It wasn't that they heard the full panoply of what they were waiving, right? The question is, did they voluntarily consent to a warrantless search, knowing that they had the right to have an independent judicial officer review what the officers were telling them? That was problem number one. There was no indication. There was a shortage, incomplete information.
Which is only a problem if, in fact, they do have the right, right? Your argument about what they heard piggybacks on your argument on the merits that they are entitled to a warrant prior to being subject to the consequences that are imposed for a refusal.
But there is no other exception being argued here except for the consent itself. We cannot use the fact of a consent to be evidence for justifying around the exception to the warrant exception itself.
Well, but the implied consent statute can bear some weight, right? I'm thinking of the analogy of the U.S. Supreme Court, and I realize Article 11 is different, but basically said, can't use that to convert a blood search, a search of your blood test, into a consent search on the basis of the implied consent statute. But we can impose consequences for refusal to take a breath test under the implied consent statute. It can bear that weight consistent with the Fourth Amendment. Why can't it bear that weight consistent with Article 11?
Well, because the way that the court got there was to analyze the invasiveness of the breath versus the blood significantly different. This court hasn't gone there. Right? And under Article 11, that isn't the question. The question is, was there a search and seizure? Both Fourth and under Article 11, there was. At that point, the analysis diverges. A warrant's required unless the prosecution can show a valid exception around it. Here, the question is a voluntary consent.
I'm sorry to interrupt you, but one of them had a conversation with a lawyer. We know what the lawyer's advice was to
No,
them.
we do not. Yes, Your Honor, Mr. Williams, no, it's Mr. Boissoneault who had the consultation with the attorney, but that's not determinative here of the question of consent because we don't know what was spoken.
Is it only because we don't know what was said?
No, I think also that it is an open question, certainly, as to whether or not refusing to submit to a warrantless search will result in a crime. I think that right now the practice is that if you refuse, pursuant to the legislatively created statute, you are subjecting yourself to being criminalized for the crime of refusal.
But that's only for second or third offense, not for the first offense.
That's right. But in terms of the question of what we can do with the fact that one of the defendants consulted with counsel on this question of consent, it doesn't provide a determination either way. I'd like to focus on what they heard, that the refusal can be used at trial as evidence of guilt. That a refusal can be, you can penalize refusing to submit to warrantless search when that is actually an exercise of the constitutional right being asserted. Now, this court has been faced with the question, but has not answered whether due process prohibits the punishment of asserting Article 11 rights. That is one of the key components of what the messaging that the defendants heard at the station, what lend their consent involuntary, because you cannot be punished for exercising a constitutional right. Additionally, they never heard that if they consented, they could revoke their consent at any time or limit their consent. Again, this is black letter law in terms of what we understand to be voluntary consent, right? Consent is only valid if they understand they can revoke at any time. And no point during the reading of the implied consent form did the defendants hear this. Again,
It's weird, though, because the time interval between when somebody gets the end of that information and when they actually do the test is pretty small. Is the thought that they might have missed an opportunity to say yes, I mean no, in that short window between when they finish the rites and when they blow?
I think the problem is certainly there is the question of was there a practical opportunity to revoke versus being told the full expanse of your ability to exercise control of the situation. To consider the fact that the power dynamics here couldn't be more skewed against the defendants, right? In this post-arrest scenario, where you have a uniformed officer, not just implicitly acting and showing authority here, but expressly stating that he is making this request under the authority of Vermont law.
So is consent, it seems like you're arguing that where there's a police officer in a uniform with a gun who asks you to do something, that's per se an issue of coercion.
Yes, I think that Bumper v. North Carolina provides guidance in that way. It certainly is a key factor. I think that when you start combining all of these factors, you cannot trust that any of this consent that the defense
Which would do away with the implied consent law.
I think it could effectively, well, in terms of how it's being instructed here.
But the police officer's still going to be a police officer with a gun on, and they're still going to be sitting in a room.
There is nothing holding the officers back from picking up the phone and calling the judge and applying for a warrant, which is what the drafters intended with Article 11. Again, we're working within what is the contours of the exception to the warrant requirement, and that is the consent doctrine. Again, whenever the court looks at these narrow exceptions, they look at it and analyze these exceptions narrowly because they are by definition supposed to be the least restrictive.
Do you agree that the state cannot force the defendant to take a test with or without a warrant?
Yes.
Okay, can you tell me why the language was taken out of 1202B that says if the defendant doesn't consent, the test shall not be given?
Why it was not.
Why was that language removed?
Why was that? Well, I think there it crosses the line to physical coerciveness. And certainly that is clear law. I think that the question is when we look at voluntary consent, it's a much more subtle question, right? It doesn't turn on just the physical conduct of the police officers themselves. It doesn't, the threat of physical violence, the threat of physically putting this breathalyzer equipment in your mouth. It's much more of what are the defendants feeling at the time.
Didn't we implicitly decide this in Edelman? I mean, we essentially said you don't have, the state doesn't have to prove voluntariness every time in sort of very case-specific ways. It could be raised as a defense, but the concept that implied consent doesn't mean implied consent to the test. It means implied consent to the consequences of refusal. And you can still raise voluntariness, but it's got to be based on specifics to that situation, not kind of a challenge to the overall scheme.
I think that, if I'm understanding you, Edelman certainly held that we cannot rely on the implied consent statute to provide the constitutionally required voluntary consent. We have to look at the individual's circumstances. What Edelman didn't get to do was look at what the defendants hear at the station. And this case presents that. And when we look and break down what they hear, it establishes a situation where defendants, we cannot trust that their consent was voluntary. Certainly was not knowing. Nowhere in the readings did the officers tell them that they had an Article 11 right to a warrant. How can you make a voluntary consent to waive your right to a warrant without knowing that that exists? It's problem number one. But that just goes, there are more problems, as I listed in the brief in here. I will save the remainder of my time for rebuttal.
Okay,
Thank you.
thank you. Counsel, please.
Good afternoon, Your Honors.
Good afternoon.
I think this is different than different than a search if you go to someone's house or finding someone on the street. As Justice Robinson has noted, this deals with implied consent where there is a bargain. Someone's driving on the roads, which is a privilege. It is not a right to drive on our roads. And in order to do that, we have seen where the court has before looked at that privilege and how there is this balance of public safety. We have to make sure people are safe on our roads. And they've said in McGugan, I've never say that correctly, albeit a roadside test, it's the same exact search. And that is a reasonable warrantless search. It's reasonable to ask for someone to take their breath in order
Well, no, they have to have some reason to ask for it.
Yeah, I was just going to get there. So it's not like you're stopping someone and they didn't use their turn signals, automatically give me your breath. Absolutely not. And that's another reason why it is reasonable that we're asking for this. We're not just randomly asking anyone who's driving a car. The officer has to see what essentially is akin to probable cause that someone is operating under the influence. And that's a heavy lift.
So, but one of the things that was puzzling me about your argument is, in the Fourth Amendment, the U.S. Supreme Court has construed that the way that you're applying Article 11 here. There's sort of there's a reasonableness balance. Reasonable search means kind of doing that balance. We've so far rejected that conception of Article 11 and said that the reasonableness balance has already been struck, and it says you need a warrant. And there are specified exceptions, but you have to fit within one of those. You don't get to say, well, in this case, it's reasonable. You have to articulate an exception. What's the exception here?
But in State versus Therian and State versus McGugan, there was no warrant. And it did say it was reasonable as long as the officer had the reasonable articulable suspicion, then they could request the
And
test
those were
they didn't need the
extensions
warrant.
to the very limited doctrine for roadside stops, right? I mean, and arguably imported seizure law into search law, but in any event, it was tied to that roadside stop. This is taking somebody into the station. It's a much more prolonged thing.
But they have the same reasonable articulable suspicion of the same crime. They're at the station. It might take a little bit longer. It's actually not that much longer than the roadside. And Therian and McGugan didn't say this is only limited to roadside and only limited to that you have to be within a certain amount of time.
So
It
is
was
this another categorical
test.
exception to the warrant requirement that we haven't yet recognized? Or sort of doctrinally, how do we get where you want us to go?
Because you have to look at it in conjunction with the implied consent law, or as Justice Carroll said, we have no implied consent law, which actually gives the defendant more rights. The implied consent law, if we take that away, we're taking rights away from people. They won't get an attorney consult. They won't be told they have the right for an independent blood test. There's a lot of rights that are baked into that implied consent for the driver. And it's a quid pro quo. If you want to drive on the road, it's a privilege. We need to have the ability to ensure that you're safe when we have reached this high threshold of that we have reason to believe that you are impaired. And I think it's Morale when they said, the legislature has said, this is a consent search, albeit a consent search wherein it's paired with the law enforcement having the tantamount probable cause with consequences for refusal. And recently in State versus Schaff, it was noted in the dissent, Justice Robinson, you noted that operators have agreed to a limit on their right to refuse. And that limit is that it could be that it's a criminal for a number 2 or above, or it's a piece of evidence at trial, and there's the civil suspension that goes with that. And it is, again, as Justice Cohen has pointed out, it is for 2 or above. So not only do they get the notice that everyone does in the green books that go out, that here are the laws that we need to follow, that when you drive, you are agreeing to limits of that you will give your breath in certain situations, and if you don't, there are consequences. Now it's not for everyone. Like if you're DUI 1, there is no criminal refusal. So you've already broken the crime once, been convicted of it, gone through that process, and are told then again, second or third or fourth, there are higher consequences. And it does not, as appellant seems to suggest, it does not add. It's the same penalties you are looking at for a refusal that you would be for a DUI 2.
So if this is a consent search, if that's the exception to the warrant requirement, what's the answer to the argument that you can't voluntarily consent to or waive your right to a warrant if you don't know that right exists? What's the answer to the argument that they should be informed that they have the right to ask for a warrant?
Well, we answered that in two different ways. First of all, in Edelman, it was clear that it said, even though there are conditions on this, it's still your choice. It's still the defendant's choice. We're telling you that there are conditions. Secondly, even and I'm not agreeing, I don't agree that there is a constitutional right to refuse the evidentiary breath test, but even when there are constitutional rights, that can be paired with some chilling effects, and it has been said that doesn't mean that we're taking those rights away from you. And also, we don't have to tell them, similar to we don't have to tell them they have the right to refuse field sobriety tests. We don't have to tell them they have a right to refuse. That may be something that potentially could be looked at, but then that's on a case-by-case basis, and in this case, there was no evidence of subjective what the defendants thought. There was no evidence whatsoever. All it was is saying, we think this is coercive for these two defendants who have been through this twice before, at a minimum, that we know of, and twice before been convicted of them. One of them spoke to an attorney. There was no evidence from them. They didn't testify. There was nothing. All we had is that both officers were polite, respectful, calm, and explained to them what they are required to by law of this court to tell them. Per statute, we have an obligation to tell them, and if we don't tell them, then we have a problem. That's exactly what they did. They took it verbatim from the statute. There was nothing added by the officers. It was what this court, what the legislature and what this court has then interpreted to say, yes, you must tell everyone.
Is there anything unique specifically about these two defendants that makes it different than any other DUI 1, 2, or 3?
No, it's the 2 or 3 because they were told, as every suspect in custody will be told, if you have a prior one, it's a potential of a crime, because the officer won't know if they have a prior or not. They happen to have that prior one, so in their mind, they may be aware of that it's a crime if I refuse. There was nothing different than any other individual who's in custody. They are told the same thing every single time, verbatim from the statute, what the legislature has told us and what, again, this court has told us we need to inform them of. And in addition to that, they are given the opportunity to talk with an attorney. Nowhere else, when we are requesting consent, do we provide them and say, you have the opportunity to talk to an attorney. We do that here, part of the implied consent. Again, that's a benefit for the defendant, not for the state. I think I'm done unless there's any other questions.
All right, thank you.
Thank you.
How about the appellant? Does the appellant have time?
Appellant has 29 seconds remaining.
29 seconds, okay.
I'd like to correct the state's assertion that the consequences are the same. They're not the same. The refusal punishment is significantly harsher and coerces the defendants to then submit to a warrantless test. The civil suspension dates are double, right? And you can be charged with both DUI and refusal in theory. The second, going to Justice Carroll's question earlier, nothing prevents the state from thoroughly and accurately explaining the defendant's rights under an implied consent statutory scheme.
Okay, thank you very much.
That concludes today's hearing.